For the past 3 years, I've been deeply intrigued by the SEC's lawsuit against Ripple, filed on December 22, 2020. It's a case that has captivated many in the cryptocurrency world. Initially, it was disclosed that the SEC did offer Ripple, along with its executives Brad Garlinghouse and Chris Larsen, a chance to settle. However, the nature and specifics of these proposed settlement terms were shrouded in mystery, leaving many of us speculating about what they entailed. Hey there, Moneyside family, your trusted source for all things XRP related. Before we dive, do me a solid, smash that like button, hit subscribe, and toggle on notifications to join our community. And hey, we're rolling out an epic XRP giveaway once we hit 60,000 subscribers. It's easy to throw your hat in the ring with just 3 simple steps, so make sure you do all that. Drop a hashtag Moneyside in the comments to secure your spot. Now, after years of speculation and uncertainty, we finally have insight into those settlement terms. And let me tell you, my initial hunch was correct. These terms were, in no uncertain terms, absolutely unacceptable. They were not just unreasonable, but downright detrimental to Ripple, and by extension, to all XRP holders. The conditions laid out by the SEC were so stringent and unfavorable that they would have caused irreversible financial harm to XRP investors if Ripple had accepted them. This situation highlights the importance of Ripple's financial resilience and their willingness to stand against the SEC. Ripple's decision to fight back, backed by significant financial resources, a war chest, as some might say, was crucial. Without this defiance and the resources to sustain it, we as XRP holders could have faced a dire financial situation. The settlement terms were, to put it bluntly, alarming. It's a stark reminder of the high stakes involved in such regulatory battles and the potential impact they can have on individual investors and the broader cryptocurrency community. It could have been a complete game changer, and not in a good way. If Ripple had acquiesced to the SEC's terms, the immediate and perhaps long-term repercussions for XRP, particularly for holders in the United States, could have been catastrophic. While XRP might have continued to exist, the implications for US investors were potentially grim. The recovery path for them was uncertain, and the landscape of investment in XRP could have been drastically altered. On the 3-year anniversary of the SEC's lawsuit against Ripple, a significant revelation was made by Stuart Alderoty, Ripple's chief legal officer. Last night, he unveiled the details of the behind-the-scenes negotiations and challenges. His disclosure was a stark reminder of the critical role Ripple played in shielding XRP holders, especially in the US, from potentially devastating consequences. The lawsuit had already taken a toll on XRP's value. The market reaction was immediate and severe. Beyond the price impact, the ripple effects, no pun intended, were widespread. Countless developers who might have been working on the XRP ledger refrained from doing so. Numerous potential investors steered clear of XRP, leading to an artificial suppression of its price that persists even now. But according to Alderoty, the situation could have been far worse had Ripple complied with the SEC's demands. He's Ripple's top legal mind, their chief legal officer. His insights shed light on the gravity of the situation and the decisive steps Ripple took to protect not just its own interests, but those of the entire XRP community. Stuart Alderoty, Ripple's chief legal officer, recently revealed a critical moment in the company's history. 3 years ago, on the day the SEC sued Ripple, Chris Larsen, and Brad Garlinghouse, the SEC presented a settlement offer that would have had profound implications for XRP. According to Alderoty, the SEC proposed publicly declaring XRP as a security, giving the market a brief period to come into compliance. Ripple's response was a definitive no, for 2 pivotal reasons. Firstly, the firm stood by its position that XRP is not a security, and secondly, because the SEC had failed to establish a clear framework for cryptocurrency compliance. Alderoty underscored that the essence of this legal battle was always about establishing that XRP in itself is not a security. By rejecting the SEC's settlement offer, Ripple took a significant risk. Few believed they could win against such a formidable adversary, but Ripple's resilience not only led to a victory, but also exposed the inconsistencies and overreach of the SEC. This fight was about more than just Ripple. It was about safeguarding the broader cryptocurrency industry in the United States. Now, looking forward to 2024, Ripple's stand against the SEC has set a precedent. The offered settlement, had it been accepted, would have fundamentally altered the fate of XRP XRP, particularly in the US, for untenable reasons. It would have been disastrous for American XRP holders, potentially causing irreparable harm. While XRP had legal clarity outside the US, the uncertainty and ambiguity within the country could have deterred innovation and investment, affecting the global perception of XRP. In such a scenario, it's hard to imagine the path Ripple and XRP would have had to take. But one thing is clear, Ripple's decision to fight back has been pivotal in shaping the present and future of XRP. The unfolding saga of Ripple's battle with the SEC has been nothing short of a legal thriller. The stakes were incredibly high, not just for Ripple, but for the entire cryptocurrency ecosystem. Had Ripple conceded to the SEC's assertion that XRP is a security, the repercussions would have been far-reaching and potentially catastrophic. It would have set a precedent that could have forever wrecked the future of XRP and possibly other cryptocurrencies. Attorney James Murphy, known as Metal Almond Online, recently returned to the spotlight after an unjust suspension from a platform. He addressed Stuart Alderoty directly, commending Ripple's refusal to succumb to the immense pressure exerted by the bully, the United States government. His sentiment echoes the relief and admiration felt by many in the crypto community. Murphy's words, "Very few companies and executives have the fortitude to refuse to give the bully their lunch money," encapsulate the David versus Goliath nature of Ripple's stand against the SEC. This was a fight where Ripple, despite being the underdog, managed to achieve sweet vindication. The scenario seemed dire initially, with many seasoned securities law attorneys predicting a grim outcome for Ripple. Despite the pervasive skepticism, Ripple's resilience in the face of such a formidable adversary as the SEC was remarkable. Attorney John Deaton, who wasn't a securities attorney by original profession, brought a fresh perspective to the situation. His confidence that the SEC wouldn't win this battle contrasted sharply with the more defeatist attitudes of others in the field. His fresh eyes and different approach to the case provided a glimmer of hope amidst widespread pessimism. Additionally, attorney Bill Morgan summed up the situation succinctly, suggesting that the SEC's ultimate aim was to force Ripple into capitulation. This would have created a domino effect, setting a precedent for the entire cryptocurrency market and potentially leading to widespread classification of cryptocurrencies as securities. Such a move by Ripple would have had profound implications for other developers and the broader crypto industry, likely becoming a reference point in subsequent litigation against other cryptocurrencies. The refusal of Ripple's top executives, Brad Garlinghouse and Chris Larsen, to concede to the SEC's demands was a defining moment in the legal saga. Had they agreed to label XRP as a security, the ripple effects, no pun intended, would have been immense. It would have been a convenient escape for them personally, but at the expense of the entire XRP ecosystem. They faced intense pressure, a form of regulatory bullying, yet they stood their ground firmly. It wasn't until recently that the SEC withdrew its cases against Garlinghouse and Larsen. This move was telling. It underscored that the cases were more about intimidation than about any real legal contention. The SEC's tactics were clear: to pressure Ripple's leaders into submission. However, Garlinghouse and Larsen did not yield, refusing to validate the SEC's unfounded allegations. Attorney John Deaton's commentary on the third anniversary of the lawsuit adds another layer of insight into these events. He pointed out that just one day before the lawsuit was filed, Jay Clayton, then head of the SEC, had met with Gary Gensler. The very next day, the lawsuit against Ripple was filed, marking one of the most significant non-fraud enforcement actions in modern history. Deaton suggests that the timing was more than mere coincidence. It was likely a calculated move. His assertion that the case must have been discussed between Clayton and Gensler the night before is compelling, though we may never know the full extent of these discussions. What is apparent, however, is Clayton's determination to ensure the lawsuit's filing before his departure from the SEC. It was his final act in office, and it seemed orchestrated to cement the SEC's stance against Ripple and XRP. His decision to file the lawsuit on his last day speaks volumes about his intentions and the strategic nature of the case's timing. Please remember, I am not a licensed financial advisor. The content presented in these videos is purely for entertainment purposes. I always encourage viewers to conduct their own research and consult with professionals before making any financial decisions. Thanks so much for tuning in. If you enjoyed the video, please give it a thumbs up and don't forget to hit the subscribe button. Also, make sure you turn on the notifications to be the first to know when I release new content. I'm excited to catch up with you in the upcoming video. Take care.